So Tim, I think the first question's for you here, and can you share with us what the protocol is for nursing homes with respect to testing residents who have COVID-19 symptoms? Do they have to do these tests? Can they just isolate these residents?
Nursing homes have always been required to evaluate their residents for any sort of respiratory problem. Obviously, under the circumstances of this pandemic, their responsibilities are higher. They have to test anybody who qualifies under those tests, and obviously the standards for how someone qualifies to be tested for COVID-19 is constantly evolving. But what's important is that the nursing home has to notify the health department about any residents who have severe respiratory infections or any group of more than 3 people, either residents or workers who have a new onset of respiratory symptoms. So the second part of your question is, well, what do they have to do once they identify somebody who may have COVID-19? And it really depends upon whether or not they require a higher level of care than the facility can provide. If they do, then they need to be transferred to a different facility. If the facility has the ability to care for somebody with their symptoms, then they are expected to provide them that level of care. That may involve things like wearing a face mask if tolerated, being separated from others, like being kept in the room with the door closed. And of course, it's going to be important that the nursing home provides its workers with personal protection equipment that they can use when interacting with any of their residents. All right, I think the next question would best be answered by you, Laura. So if you can let me know the answer to this question, which was submitted by one of our viewers, which is, my employer thinks that I'm an essential employee, but I don't think I am. What can I do?
So right now, I think the only guidance we have on this is coming from the governor's executive orders, which has basically identified specific types of businesses as non-essential and that shouldn't be open at this point in time. The extent to which you could not show up for work in reliance on that executive order, I think is really unclear at this point in time. And so our general advice would be, if your employer is still open, they're expecting you to come to work, unless some other protection applies that might come into play that I think we'll discuss in some of the later questions here. Normal employment rules apply. So if you stop showing up to work, your employer can terminate you, under normal employment practices. So at this point in time, there's not, as far as we're aware, any specific new protections that would apply in this situation where you disagree with your employer as to whether or not you're an essential employee. So I think the next question here has to do with just some kind of general litigation stuff, and I'll pitch it to you, Tim. The question is, I have a deposition coming up. I'm someone who has a case filed and I have a deposition. How is my attorney going to handle this?
Well, the best way to answer this question is to call your attorney. But in general, what is happening around the state of Iowa is one of two things. Either depositions are being postponed until a time when it is safe to have attorneys, witnesses, court reporters in the same room, or if the deposition needs to be done sooner than that, and if the parties agree, the Iowa Supreme Court is allowing depositions to be done remotely whenever possible. And by remotely, we're talking about doing something like this, using technology like Zoom or some other sort of remote video conferencing technology that allows not just the questioner to be in one place and the witness to be in another place, but also involves allowing the court reporter to be in a different place. And our office has been doing remote depositions for the past several weeks now, and I'm surprised how well they're working. But the quick answer to your question is call your attorney. They will tell you whether or not your deposition is being postponed or whether or not it's something that can be done remotely.
There's another question for you, actually. So this question is about someone who has a potential personal injury or workers' compensation claim, and they want to know how they can get a hold of an attorney at this point in time.
Well, I wouldn't recommend trying to drop by an office. Most law offices are not open for drop-in people from the public coming in. It's just not safe for people who are working in the offices or the people who would be coming in. A lot of offices are allowing their employees to work remotely, so that means they may not even be at that location. So the best way to get a hold of an attorney to get questions answered about a personal injury case or a workers' compensation case is to call. A lot of these offices where people are working remotely are having their phones answered off-site, or if the lawyer has a website, you can go to their website and request a consultation. And either that can be done by phone, by email, or a service that we're offering for our clients now is to do video conferences. If you have access to the technology, all the lawyers in the office here are capable and have the tools necessary to do a video conference with any prospective clients.
And when you say if you have the technology available, I mean, my understanding is all you need is a smartphone. Is that your understanding?
Yes, if you need internet access and the ability to record yourself, and so a typical smartphone or a laptop or a tablet typically has what you need as long as you have a good internet connection.
The next question has to do with notaries and getting documents notarized. Do you have information about how people can get that done right now?
Yes. So the first thing that you need to understand is that the Supreme Court of the state of Iowa has relaxed the standards for which documents need to be notarized. And so the first question that you should get an answer to is, does this document actually need to be notarized at this time? And your lawyer should be able to answer that question for you. If it does need to be notarized, the Supreme Court has set up a process where anybody who is qualified, has a certificate to be a notary, can do that remotely. And in a nutshell, what it involves is it involves some sort of video access where the notary has the ability to watch you signing a document so that they can attest legally that you are the person who signed the document. But I would anticipate that in the majority of situations, the document that you have right now, the Supreme Court has said it doesn't have to be notarized under current circumstances. All right, looks like the next question is something that you would be best suited to answer. It asks, can employers reduce employees' compensation during this period of economic uncertainty?
That is a good question. I think a lot of people are probably working for employers in Iowa who are facing some economic uncertainty and trying to make some very difficult business decisions going forward. Some employers may be looking at their list of employees and deciding rather than fire people, let's just reduce everybody's salaries. So what to keep in mind about these things is, first, your employer can't retroactively change your pay, so they can't go back and change anything prior to the date on which they implement the change. Going forward, unless you're protected by some sort of collective bargaining agreement or under some sort of contract of employment that might come into play, if you're a general at-will employee in the state of Iowa, your employer can make changes to your pay going forward. The key thing to keep in mind with this is that normal employment law protections continue to apply and exist even in the circumstances with COVID-19. So if your employer is going to make decisions like this, they can't do so in violation of for example, the Iowa Civil Rights Act, which protects against discrimination for protected classes based on age, race, disability, religious beliefs, and those sorts of classifications. So there's still an obligation to not discriminate. And then the other thing to keep in mind is that there are some new laws coming into play that affect things like sick time and paid leave. And we actually posted a video on our Facebook feed recently that addresses some of those issues. So, I refer to that video as well, as it contains a little bit more information about what those laws are providing. But, again, general employment protections still apply. But if you're an at-will employee, there can be a reduction in pay going forward.
All right, the next question is, are employees who are laid off temporarily, so for example, furloughed, are they entitled to paid or unpaid leave under the FFCRA? And
Yeah.
first, it would be helpful for somebody like me to explain what the FFCRA is.
Yeah, so let's start with that. So the FFCRA is the Families First Coronavirus Response Act. That's the act you've probably been hearing a lot about in the news that was passed by the United States Congress and signed by the president. That law is the subject of that Facebook video that we posted on our firm's website, so you should be able to access that video and look at it. The law provides some protections for sick leave on top of what employers might already provide, and it also expands some of the FMLA protections. So those are discussed in more detail in that video. For purposes of this question, there's kind of a difference between a layoff and a furlough. So a layoff would be where your employers actually decided to terminate your employment relationship. A furlough would be sort of you're on leave, but you're still an employee. You could be called back. So under those kind of conditions, what the FFCRA, so the Families First Coronavirus Response Act, provides for is if you are a current employee, so you're still employed, then you may be entitled to some additional sick leave. I think it's a little up for debate whether if you're on furlough, you would still be considered an employee. Probably if you're laid off, you would not fall under that act. But on this point, I'd encourage people to go to the Iowa Workforce Development website where you can apply for unemployment benefits. There's been also a lot of movement at the national level to expand unemployment benefits. That law is called the CARES Act. It's in the process of going into effect. States are working on getting the system set up to handle the increased unemployment claims that are being filed. And that law also provides for some extension of existing unemployment benefits. So I'd encourage anyone who finds themselves in this situation to go ahead and contact the unemployment office. The best way is probably going to be through their website. Their phone lines are probably very busy right now, but get those unemployment applications in. They'll be processed in the order they're received, and there's some extended benefits available there.
Next question. Are employers required to allow employees to work remotely?
It's a good question. I think, a lot of employers are trying to do that where they can. There is nothing in the current executive orders or in current legislation that makes that a requirement for employers. So it's going to be at the discretion of each individual employer at this point in time, at least with respect to those businesses that are still open to the public. Generally speaking, again, the normal employment law protections still apply. So, the employer, if they're going to allow some employees to work remotely, but not others, you got to make sure that their basis for making those decisions is a legitimate business reason and isn't in somehow discriminatory or singling out people of a particular protected class. And again, I'm referring to those people that might, be disallowed from working remotely when other people are, and you can point to age or race or religion or disability or sexual orientation as the reason the decision was made. So to the extent your employer's treating similarly situated people equally in those decisions, and generally following employment law, they can make those business decisions. The other thing to keep in mind for individuals who, the Americans with Disabilities Act comes into play here as well, and that in Iowa falls under the Iowa Civil Rights Act. So if you are an employee who may be entitled to an accommodation in the form of working remotely, that is a potential avenue to explore. That's going to be very dependent on what the underlying health conditions are that are giving rise to the need for that. Potentially autoimmune conditions would be a basis for applying for an ADA accommodation to temporarily work remotely. Those accommodation issues are very factually dependent on what the business is like, what the nature of the business is, the feasibility of doing remote work, whether there's an undue burden on the employer, so that there's a potential avenue there, but it's going to very much depend on each individual person's situation. But generally speaking, there's no legal obligation to allow remote work right now.
Next question. I understand that older individuals or those with certain medical conditions are more at risk for COVID-19 infection. May I have different policies for certain employees? So it sounds like this question is being asked by an employer.
Yeah, and to kind of clarify here, typically the cases that I'm seeing are coming from employees and not from the employer perspective. Generally speaking, as I've kind of said in answer to some of these other questions, is that general employment law protections apply. So, discriminating against employees on the basis of their age or their disability is going to continue to be an issue that comes into play with the Iowa Civil Rights Act or the Americans with Disabilities Act. In terms of those sorts of protections, you can't create these classifications within the work system that group people by those classifications. So at this point in time, we're not seeing anything that forces us to set those normal protections aside. Not seeing anything coming down in the executive orders that is allowing employers to, separate off the high risk individuals who work for them.
Next question. Sounds like this one comes from an employee who maybe believes that they've been exposed to COVID-19, or they were in a location with a significant amount of COVID-19. And so the question is time spent self-quarantining without symptoms protected by the Family Medical Leave Act?
I think the question there is referring to sort of this general idea of social distancing, that you're not under the care of a doctor, you're not experiencing symptoms, you're just generally trying to do what all of us are trying to do, which is reduce our interactions with other people to help prevent the spread of the virus. As it stands right now, the FMLA would not provide some protection for that general, I just want to socially distance and I want to be able to take leave off of work so that I can do that. That video that we have on our Facebook page does talk about a new part of the FMLA that came out in this Family's First Coronavirus Response Act, where if you have a child whose school or daycare provider is unavailable because of COVID-19 and you have to be absent from work to take care of that child, then you may be entitled to some FMLA protections through that avenue. Apart from that being at play, just normal social distancing is not going to be the basis for an FMLA case. If you get symptoms, if you get a diagnosis, then you yourself may fall under just normal FMLA protections, and that would depend upon whether there's a doctor who's going to sign off on paperwork saying that you have a significant health condition that prevents you from being able to go to work. Potentially the extended pay come into play, so I'd encourage you to look at our video on those issues. And then You know, but generally we hope everyone stays safe and healthy out there, trying to walk that line between social distancing and taking care of your families.
All right. Well, it sounds like those are all the questions that we have at this point. I know that either through Facebook or our website, we're getting additional questions coming in, and I'm sure as long as those questions come in, that we'll take opportunities like this to try to answer them. Thanks.
Thank you.